I'm not even going to attempt to summarise the richness of the discussion that we have on the board. So I'm going to leave it there for you to see and just pick up on a couple of points that were made. So there's some that were interesting. There's lots of crossover between the different groups. One of the points that was made is that we need to find what's an appropriate framework in Scotland, so something that fits with our political, constitutional framework and legal and judicial culture, which is clear. There was also a point that someone's made that maybe we need a new Act, an Economic, Social and Cultural Rights Act, and there's obviously questions as to what that would look like, what it would include. One of the points that came up a lot clearly is education and capacity building, and that went across all of the different groups, from civil society and rights holders to the Parliament, the government, the legal profession and the judiciary. And in that, a need for acceptance of the justiciable nature of economic and social rights. So I've got some sort of key questions that have come out of this and have come out through the day that I just want to have very short, sharp responses from our panel of experts on. So the first one was around this related to education and understanding of economic and social rights, and whether or not we've got a deep enough understanding of those rights and what they mean. So how well defined are those rights? How well understood are those rights? And I want to go first very quickly to Virginia to answer that question.
Well, I think the rights are better understood now. I'm not saying they're well understood, but I think they're better understood. And I sometimes think this education, awareness raising, capacity building is a kind of a panacea, which it is not. It is important to have it, and I think institutions like the Scottish Human Rights Institution and other people are doing a good job of it. But finally, that helps, that will push for rights further. But I think at heart is this understanding that economic, social and cultural rights are different, are all about progressive realization, are not really enforceable. I don't know if education and capacity building can take care of that very deep, I would call it, misunderstanding. So, yes, capacity building, yes, awareness raising, yes, education, but I think you also need the political push, and you also need a more proactive approach to economic, social and cultural rights.
Thank you, Virginia. Another issue that's come up on the board is around, legal education and the confidence of our lawyers to raise international human rights law arguments in litigation and the receptiveness of the judiciary to hear those arguments. So I'm going to ask Colm, really, what the role of judges should be in holding to account for economic and social rights violations, and what are the challenges for them in that type of adjudication, and how do we overcome them? Small question.
Yeah.
Please.
Very briefly, any judge is going to be worried about legitimacy, and any judge is going to be worried, do I have the legal power to be listening to these arguments? And any judge is going to be worried that they are getting arguments that are vague and well-meaning and policy-orientated, and that they're worried they're being sucked into politics. Okay, that's understandable. If I was a judge, I'd be worried about that too. So, for practitioners and activists and others making arguments, I think, the focus is on very much on, these are standards. These are standards which exist in international law, but these are also standards which have their echo in domestic law. As I said, you could reconfigure an English and Scottish socioeconomic rights law from administrative law. You could change certain decisions, tweak certain things, and you'd almost be there. And I think that's an important point to make, that this isn't something earth-shatteringly alien. And I think it's also important to sort of emphasise that if you want, we're not talking here about politics by another means. It's more complicated. We're not sort of smuggling in a sort of Labour left agenda through a sort of woolly human rights language. Some people are trying to do that, but that's going to, no judge is going to go, oh, I'm not going to be suckered into that. Instead, the emphasis has to be, these are established norms, international level, domestic level, here's what they mean, here's how they can be given concrete and containable legal shape.
Great, thank you, Colin. And the final issue that I wanted to draw out came less perhaps through this exercise, but in the previous exercise where we looked at different constitutional provisions and then ultimately what a court or a parliamentary committee did with those constitutional provisions, we saw that there really was a vast array of remedies that could be drawn on in other jurisdictions. And certainly at my table, there's a lot of raised eyebrows about how far some of those remedies went and their potential appropriateness in a Scottish context. So I'm going to address this final question to Katie about what remedies in law can be made available in Scotland and what impact might they have, drawing on your research.
Thanks. So I suppose I should just revisit one of the caveats that I mentioned earlier, which I don't think there would be a lot of disagreement about this, that essentially you should create a culture of human rights and a human rights-based approach in all areas that engage with human rights without having to go to court. That really, it should be something that is a means of last resort if all else fails. And in that multi-institutional framework, that you have obligations placed on the different branches of government, legislative, executive and judicial. But that remedies in court are an important aspect. They are an aspect of international human rights law. There is what is termed a right to an effective remedy, and it's when things go wrong. It's not your first port of call, but when everything else fails, that an individual who has experienced a violation of an international human right can turn to a court of law for an effective remedy. Now, sometimes those remedies may be more appropriate if they are deferential and quite, it would be sort of, termed as weak form review and deferential remedies, where the court turns around and suggests perhaps to a decision-making body that it might be wise to rethink a policy or a particular approach, and sometimes they may need to be more robust. So if you think of the Napier case, a breach of Article 3, it's a quite high threshold to meet, and the Scottish courts took a very clear view that it was slopping out in Scotland amounted to inhumane and degrading treatment, and that remedy was required. Now, again, in that case, it wasn't that a particular law was struck down, but a policy that was in place was ultra vires, and damages were issued. Now, as a result of that, the policy changed, and slopping out was no longer something that happened. So it's about trying to find different approaches, and I think when you deal with socioeconomic rights, you need to start to consider new and innovative ways of providing remedies within particular circumstances. Sometimes it may be that the court might perform a supervisory function. Say, for example, a public authority has not fulfilled a statutory obligation in relation to economic and social rights, that they may give them a period of time to do so and then revisit it. Or it may be that you encounter systemic issues in a particular area and the court has the power to overview the structural problem. Or it may be that it is something more appropriate to a declaration which recognises that there is an issue and that it would be wise for the Parliament or Executive to revisit. And so it's about trying to find the broad array or the constellation of remedies available and picking the right one in the particular case. And, that's something which is important in the context of exploring socioeconomic rights and their enforceability.
Thank you. Thanks, Katie. So you've absolutely all fulfilled your brief as given in terms of elevator response to some of these challenges. Do any of you want to add anything in terms of those issues around defining and understanding rights, the role of judges or remedy?
No, I just want to call attention to the fact that most of the time we speak of social and economic rights, and the cultural rights are kind of either forgotten or swept under the carpet or left for a next meeting. Or and I know that is a common position now in UK, for example. I have very good friends who are experts on the issue and look at cultural rights in a different perspective. And maybe in Europe it is something that is debatable, but in the rest of the world, cultural rights really interconnect with social and economic rights in a way that is absolutely clear. And if you look at issues like gender discrimination, if you look at issues like women's lack of access to economic opportunities, I mean, there is no way you can leave the cultural rights out of it. Yeah. And I fear sometimes, I know that we do not intend to do it, but I fear sometimes that in our general discussion now about efficiency and effectiveness and, best use of resources, we forget something that is fundamental, that is at the core, actually, of this discussion, which is the cultural specificities of countries. And now that there's so much talk about human rights being European and, this whole issue that's really complicated and dangerous, I think we should be careful to not to forget that it's part of the rights are indivisible and cultural rights are part of those indivisible rights. Yeah, that was not my question, but I think
that's a really critically important point to make, Virginia. So thank you so much. And I thought it was really interesting that you raised that point in your interview on GMS this morning. Around technological advances and around the work of the committee in relation to cultural rights.
To be totally honest, Kavi, that was not my merit. It was the interviewer who asked me out of the blue, what about the cultural rights? And I was really happy. I wasn't expecting it, but I was happy. It gave me a chance to speak a little of Article 15, which I think is a very neglected article of the Covenant, really. But that's what life is.
Thank you. Thank you so much for bringing that to our attention. I think that's really important. Great. So we have made up time. I'm going to pass back to Judith and we'll very quickly rearrange the panel for our final session of the afternoon.
So we can sit? Yeah.
I think we can.
We can still sit, right? Well, that's it. We don't need to meet anymore.
Your work here is done. Oh, yes. So can I ask Douglas, Carla, Kirsty, Jamie and Kirsty to come and join me? Excellent. Pardon? Yeah. Okay. Sorry, I've got Kirsty. Apologies. Wow. I'm going to introduce you not in order of where you're sitting, but that's okay. But I am going to introduce. We thought really the opportunity of this session is to really hear from some of the practitioners from around the country in terms of the conversation we've been having today, and to get some reflections on that. It's no small task, so thank you all of you for agreeing to do that. And I'm going to really give people initially 5 minutes each to share their sort of thoughts following the discussion and the conversations we've been having today. And then really we'll open again to you to contribute your own reflections, or to ask questions, or to just keep the conversation going for a little bit longer. First of all, and I'll come in this sort of order, Douglas Hamilton, who's currently the chair of the Poverty and Inequality Commission. He was also a member of the Commission on Social Mobility and Child Poverty, and served on the Scottish Ministerial Advisory Group on Child Poverty. He was previously the head of Save the Children in Scotland, and is former chair of the Scottish Alliance for Children's Rights. So I'm going to go along the whole panel. I'll introduce them all, and then we'll come to each one. Carla has already introduced herself in her questions this morning. Today, she is a solicitor at Child Poverty Action Group, where her caseload includes legal challenges to lowering the benefit cap, the two-child rule, different aspects of universal credit, and the successful challenge of DWP's curbing of appeal rights, where benefit claimants put in a late review request. So no small or insignificant undertaking there. Kirsty Thompson is one of the founding directors of Just Right Scotland, which is Scotland's legal centre for justice and human rights. The centre responds to gaps in social justice, rights and equality within Scotland through cross-sector collaborations. She has a specialism in women's rights, children's rights, human trafficking and asylum and immigration law. Jamie Burton is the head of Doughty Street Community Care and Health Team. Jamie is a public lawyer with expertise in judicial review and human rights. His main areas of practice are human rights, social and clinical care, housing, social security, and actions against the police. And finally, Kay Springham of Compass Chambers specialises in civil litigation, particularly in areas of public law and reparation. Her public law practice includes judicial review, statutory appeals, and one of the few public inquiries in Scotland. She is retained by the Scottish ministers to act on their behalf and is also appointed to the A-list panel of counsel for the Equality and Human Rights Commission. So we're really delighted to have such a kind of broad range of practitioners who are really working in all the fields around economic, social, cultural rights in Britain today, and also not just from Scotland but from the wider other jurisdictions. So thank you for that. I am going to start, Douglas, with you to really give us your thoughts on where we've got to today.
Okay, thanks, Judith. I've said this to a number of people today, but actually kind of giving the wee biography there, where I should have started actually was I started my career as administrator/rights officer for the Scottish Council for Civil Liberties, with a small office which was with Kay and Alan. and this is, but it's great for the 20 years down the line to be kind of coming back into this, because actually my career's taken me away in many ways from looking at core human rights issues, I've not thought about the International Covenant on Economic, Social and Cultural Rights for quite a long time. As Alan reminded me earlier, I was barely in the door in Holland Street, and Alan said, there's a conference in Senegal about International Covenant on Economic, Social and Cultural Rights, you want to go? As I just straight out of university, I thought, this is brilliant, what a job. But what was interesting about that was a conversation that was taking place internationally, but there was very little happening here around International Covenant on Economic, Social and Cultural Rights. I came back, I think that was something that we kind of did a bit more on. We were reporting, my first engagement with a UN committee was drafting and helping to work on a submission around the International Committee, the committee on the chair of today, looking at the UK response at that time. And it's clear that a lot has changed in those 20 years. First of all, what changed, I think, was significantly was the Human Rights Act coming in, which then brought a big attention into civil and political rights, as was mentioned earlier on. It was interesting to reflect on the impact that's had, and where then the conversation with economic, social and cultural rights then went, or didn't go necessarily. One of the last things I was involved in with which became the Scottish Human Rights Centre from SCCL, was the establishment of the Scottish Human Rights Commission. And I think at that time, we were then looking to seeing, well, you've got the Human Rights Act doing this bit over here with civil and political rights. Actually, the Human Rights Commission could be the vehicle, a vehicle in Scotland for helping to promote economic, social and cultural rights in a more substantive way. And I think it's really exciting to be at this event today to see that this Scottish Human Rights Commission that have helped push this agenda forward. So that has definitely helped along the way. A lot of other changes since then. We never had the internet. Never mind a kind of interactive Menti thing that you could be doing. And certainly, there's a lot more numbers here than I would think we would ever had possible to discuss economic, social and cultural rights 20 years ago. A few reflections. First of all, is given that time gap, I think there is an opportunity here in Scotland, and that opportunity has to be taken while it's there. because that opportunity might not come round again for quite a while. So I think you have to take the opportunities when it was there. There was opportunities taken at the time the Scottish Parliament was going through. I can't reflect back with Alan, but there was an opportunity there around the Scotland Act to get human rights embedded, and they were taken and they were put there, as we mentioned earlier, in relation to the Scotland Act. There was an opportunity early on in the Scottish Parliament around the Scottish Human Rights Commission that was taken, and that's helped push things forward. There's an opportunity now to do something around the incorporation of the economic, social and cultural rights, which, if it's not taken, could set things back a long way. So I think it's really important we have to take the opportunity. Next reflection was, when we're looking at anything around this, it has to lead to change. It has to be about something which is change. It's not just, I'm presuming most people in here are already sold on the principle. So I think it's about looking at something which is about making a change. It's got to make a difference. And I think economic and social cultural rights, by having a particular place, will help to change the debate around a lot of the discussions we have around social policy in Scotland. And so it's really important it happens, because it will make the change. Final reflection was the bit I said at the beginning. It was that reminder of the indivisibility of human rights. And I think what the Economic, Social and Cultural Rights Covenant, along with the other covenants, do is provides that broad framework within which you can consider that indivisibility. And the danger of developing various responses to particular issues is that you then end up with a very siloed approach to different topics. So if you take the commission that I currently chair, the Poverty and Inequality Commission, it's really been noticed, I've really noticed it over the last year of doing this, just how much it crosses over with everything else. And I start wondering, why have we got a separate Poverty and Inequality Commission? And why is there a separate Field Poverty Advisory Group over here? And why is there a separate group over here looking at food? And why is there a separate group over here looking at housing? When actually a lot of the issues are, from our perspective, about lack of money. But actually that framework sits within, there's a kind of broader issue of economic, social and cultural rights. So I think that by doing this, this brings back that indivisibility and creates a broader umbrella under which we can have a more sensible conversation, avoid siloed approaches where we're looking at one issue without having consideration around the other issue. I think the consequences of not taking an approach just now, which is broader framework around the broader set of rights, could lead to even more siloed approaches, because every campaign group, and I'm not knocking the campaign, I've been in plenty of these campaign groups over but these campaign groups are taking particular issues, you then end up with a response which sets up another body or another framework which looks at that, and it should be considered more broadly, looking at the interaction and indivisibility of those rights. And then the final point was, I think when Colin was speaking, it struck me as well, is that if we had that framework in place, it might make a lot of these decisions a lot easier. You look at how complex the system has become on so many issues. When you talk about the housing example earlier on, when there was a housing framework set up, it's set up so that people have houses. That is the original intention of it. It's not set up to try and keep people out, it's set up to address a housing need. And yet the processes and the structures and the procedures that have got in place make it more complicated, make it more likely actually people have to challenge things along the way. Whereas if you had a right that said you have a right to housing, actually could cut through a lot of that, those processes and procedures to actually say, well, but at the starting point is we have to try and get somebody a house. Then let's work everything out from there. So I think it could end up making a lot of decisions a lot easier and get us to the place where politicians want us to get to and where society wants us to get to. So I've had the advantage of going first. Sorry, I could.
That's great.
Sorry, thank you.
Thank you very much, Douglas. Carla, would I move to you next?
So I just want to give some context. What I was told to speak about was reflecting on the day and drawing from experience as a lawyer or advocate, what are our views on the justiciability of economic, social, cultural rights standards. Yeah, so that was the remit I was giving, and being a good lawyer, that's what I'm going to speak to. I don't know what remit Douglas was given, but from the reflections, maybe they were different ones.
Slightly less specific, yeah.
But anyway, so as you can tell from my accent and from the introduction at the beginning and what I said when I asked my first question, I don't speak to the Scottish context. Yes, I'm speaking as a London-based lawyer working on, cases before the High Court, Court of Appeal, and eventually they'll come to the Supreme Court, which does govern Scotland as well. So, a bit of an apology for that. But what I do want to endorse is what has just been said by Douglas in relation to there's an opportunity here in Scotland. Yes, we're not having conversations like this down south of the border. So, you're all in your room. Scottish Human Rights Commission have done a huge amount in terms of pushing the right to social security, economic, social, cultural rights agenda. CPAG, Scotland has been involved in that, but seize this moment. Yes, the fact that there might have been a few knockbacks in relation to the passing of the Social Security Act, it doesn't necessarily have all the amendments that you were hoping for. Don't let that be the end of the process. That's just the beginning of the process. So there's opportunities here in Scotland. Seize them. Okay, getting back to what I was told to speak about. So justiciable, for those who non-lawyers in the room, can it be litigated? Can a matter be taken to the courts? Well, focusing on the right to social security, which CPAG, we do focus on welfare rights. So looking at right to social security, which is Article 9 of the International Covenant on Economic, Social and Cultural Rights, the right to social security can be litigated. Yes, 60,000 cases were brought between October and December of last year before the Social Security Tribunal. Yes, so day in, day out, people are litigating social security issues. But that's social security within the context of, we, the UK government, have decided to give particular welfare rights, welfare benefits. These are the terms on which we've given them. And, you bring your appeal questioning those, saying that, I consider I comply with those terms. Yes, I fit this particular descriptor in relation to my mobility, and therefore I am entitled to PIP. That's what those appeals are about. And they're being litigated day in, day out. But what if you don't agree with the terms or the conditions set for qualifying for a particular form of social security? So, benefit cap. What if you don't agree with the fact that a lone parent with 5 children is meant to live off £20,000 a year? The abusive partner who's walked out of the relationship and who isn't working, is claiming job seekers allowance, he's not going to be subject to the benefit cap. He's never going to reach that 20,000 limit on benefits. It's the woman, it's the lone parent, who's left carrying the can. What in relation to two-child limit? Yes, you've got a family who they've been managing fine. Apart from child benefit, they've never drawn on social security. Husband has an accident at work, can't go back to work. They eventually need to claim welfare benefits. They've had 3 children at a time when they could fully provide for them. They come to the state, which is meant to provide the social security net, and the social security net's not available for them because of a policy which is meant to be assisting people to make choices about how many children they have. Well, they made the choice at a time when they were able to provide for those children. Nobody can predict what's going to happen throughout the 18 years of the life of your children. What about disability living allowance and a requirement that to qualify for disability living allowance, you have to live in this country for 2 years? It's called the past presence test. It doesn't apply in relation to EU citizens, but it does apply in relation to a British family where husband and wife spent 10 years fully working since the age of 16, since leaving school at 16, have paid their national insurance contributions. They decide to make a new life over in Australia or over in New Zealand. They have 2 children there. They have a further child who's severely disabled. And they try and manage life in Australia, but the Australian system is letting them down. They get to the point where they have to relinquish the child into foster care, and the child is actually abused by the foster carer. And they reach a point where we cannot relinquish our child to the care of the Australian state. Yes, and at the same time, they've got elderly parents back in the UK who need support. So they decide to come back here with a severely disabled child who needs 24-hour care, and they're told, OK, that's fine, we recognise the needs, but the child hasn't been here for the last 2 years. So you can wait for 2 years. So you're not entitled to disability living allowance. You don't get any blue badge for mobility, even though they need a specially adapted car to have any quality of life. The husband goes out to work. The wife can't work because she needs to provide full-time care to the child, but because she doesn't get the disability living allowance, there's no carer's allowance. And although they're entitled to child tax credit, they don't get the top-up disability elements. So I think a lot of you in this room will be saying, OK, all those three situations are unfair. Yes? I think the basic person will recognise benefit cap being applied in that situation, two-child limit in that situation, DLA past-present test in that other situation. Those are unfair. But what can we do about it, apart from just wringing our hands and saying they're unfair? Well, all of those issues can be legally challenged. And as in the introduction to me, we are challenging those. There's certain ways of challenging them. So in relation to the two-child limit, some people might know there's an exception if you look after a kinship care child. But that kinship care child has to be the third or additional child. So if a woman has if a woman for a partner has a child, they then separate. She's a lone parent for a few years. She then meets another partner. They move in together. That partner's own daughter has had a teenage pregnancy, isn't able to look after the child, so essentially the grandchild. So they bring the grandchild into their relationship. Quite traumatic. The child's got emotional issues. There's no bonding between him and the step-grandmother, but she feels a sense of duty to look after him. So own child, kinship care grandchild. The couple then want to have a child of their own, the first child that they will have together. Well, actually, they don't qualify for the kinship care exception in that situation because the child who's the kinship care child is the second child. You've decided, you've made a choice to go and have a third child, and it's for you to be able to manage financially. So we challenged that we didn't mention human rights in that particular aspect of the challenge. We challenged it on traditional judicial review grounds, so irrationality. So the exception is all about encouraging people to take in children who otherwise would be in local authority care, which costs the state and costs the child emotionally. So that was the aim of the exception. So having it apply only if the child is a third or the fourth or the subsequent child, and not if it happens to be the first or the second child, we argued was irrational. Because in fact it would discourage people from taking in children as the first or second in that situation. And we won. So if you can read the judgment, it's two short paragraphs. So no human rights language, economic, social rights language being used, straight irrationality grounds. Whatever you want to challenge, two-child limit, the policy per se. There's no freestanding right to social security in this country. As was said by Kavita early on in the morning, there are ways of getting at it. And the way that's been most successful is in relation to a discrimination claim. Because if you can bring an Article 14 discrimination claim, you don't need to have a freestanding right to social security, but you can rely on social security being a possession. So although the state has no requirement to provide social security, if it does provide aspects of welfare rights, social security, it must do so in a non-discriminatory way. But how do you try and challenge that? Do you say that you want a further exception for those of particular religious persuasions who wouldn't use contraception and therefore aren't able to make the same quality of choice about the number of children they have? But where does that leave people who don't necessarily have a religious objection to contraception, but for ethical reasons wouldn't engage in abortion? Yeah. So is there any other way of bringing a discrimination challenge? Potentially, you can argue that the two-child limit discriminates against children with multiple siblings, and that's the way we try to bring as broad a challenge as possible to the policy. We've been unsuccessful at the High Court in relation to that challenge, but we've just received permission to appeal last week to the Court of Appeal. So the challenge is going on. But so my point is, long-winded, my point is that these rights are justiciable. Sometimes without using language or economic, social, cultural rights at all, sometimes using the framework of the European Convention on Human Rights, but in a slightly ham-fisted way. If we did incorporate, which we've been talking about today, if we did incorporate the International Convention, we could directly rely on the provision in relation to, the presumption against retrogressive measures. Yes, two-child limit is a retrogressive measure, is an austerity measure. We could pitch up at the High Court and say there's a presumption against retrogressive measures. And the burden of proof is on the state, is on the government, that they introduced it after the most careful consideration of all the alternatives and justified by reference to the totality of economic, social, cultural rights in the context of full use of maximum available resources. Yes, the full plethora of resources available to the state, including, raising taxes, including ensuring that there aren't tax havens, etc. So the potentiality that incorporation would bring a wider range of arguments to use. But one of the points I want to make, and this is drawing on reflections, is the point that's made, justiciability is the end of the road, yes? You're only arguing, before the courts when the government and Parliament have not fulfilled their part, yes? The government, constantly, when it comes to court, it will rely on parliamentary sovereignty, okay? So even though we, the government, have voluntarily undertaken these obligations in relation to signing up to the UN Convention on Economic, Social, Cultural Rights, we will hide behind this fig leaf of parliamentary sovereignty and say, well, because of parliamentary supremacy, they've enacted benefit cap, they've enacted the two-child limit, and sorry, we government wash our hands of it. So to me, we've heard how incorporation could potentially mean that the legislature does the heavy lifting. I think that was Colm's expression. But then we've had Virginia, countering that, and even in a country like Portugal, where there has been no incorporation, the legislature in certain situations, when it backs against the wall, does not necessarily comply. So it's not incorporation per se, it's about a culture. Yes, it's about a culture amongst government, elected people, amongst government lawyers, against parliamentarians, whether or not incorporation exists. What does human dignity, in the German sense, what does human dignity in wider sense mean? And actually is the legislation we're passing in compliance with human dignity. Sorry.
Great, thank you very much. You can feel that frustration, huh? Thank you, Carla. I'd like now to move on to Kirsty Thompson, one of the founders of and directors of Just Right Scotland.
Oh, thank you. I thought I would maybe just give some reflections on the practice that I've had over the last 11 years working in the asylum and immigration field, and some of the kind of principles that have come out of that that I think are necessary when I think about access to justice or justiciability. So for the last 11 years I've worked with women and children who are fleeing or are in kind of abusive or exploitative situations, and there's an immigration link. And increasingly in that time I am fully committed to this principle of interdependence. It is impossible to remove the civil and political rights from the economic, social and cultural rights. It's often a breach of the latter that has pushed that woman and child into a situation where they've had to flee. Also, when you look at the UK just now, we have the UK government who...
Don't mention them again.
Sorry, just before I say, the UK government who are openly saying, we're pursuing a hostile climate for people who are here. And that hostile climate means interference in rights to work, rights to how people access housing, rights to how people access health. Again, that can create conditions that can lead to situations where women and children remain in abusive or exploitative situations. So for me, often the entry into or exit from those situations centres round about the importance of economic, social and cultural rights. Often a woman and child, in trying to leave that situation, will not say, I'm a victim of human trafficking, will say, I need somewhere to stay, I need a house, I need refuge. And then what happens is they enter into this grey area where they come into contact with immigration, and immigration is reserved. And that creates a grey area, which then creates confusion on the front line, which can lead to responses of, well, I'm not sure where the right exists to access refuge there, so I'm not sure where the responsibility is to provide support or accommodation. And then we don't even get into assessing whether there are any broader risks of abuse or exploitation behind that. So through my own practice, the interdependence of these two sets of rights are key. And whatever happens going forward, that must be, something really important to bear in mind. And coming to justiciability, or from a practitioner's perspective, how I would think about it, access to justice, when I think about what I see, and often it is this greyness, this lack of clarity. When that exists, it often doesn't work to the benefit of the woman or child. That's where we start to get breaches, and we start to get breaches of clear political commitments on how we treat refugees in Scotland, how our political commitment on violence against women, and indeed breaches to civil and political rights. And it doesn't, it's not intentional. There's just this grey area that exists. And very much where access to justice, where it works, you have a commitment, a real clear commitment to do X. And that comes from the top. And there's a certainty or a security with that commitment. And then there's a clarity in terms of what that means. What are the objectives that flow from that? And that doesn't tend to come from us, the judiciary or the legal profession. But that's needed, because where it isn't, that's when you get problems. And that's where you start to get problems with access and breaches. But even where you have that, you still need consistency. So you need mechanisms in order to deliver that, to ensure access. And those mechanisms must be consistent with what we know in Scotland, with our norms, and consistent with what those objectives are trying to achieve. Where there's clarity, where there's commitment, where the objectives are clear, where the parameters are clear, I don't foresee any problems with the legal profession or the judiciary playing a role. Often the types of judicial cases that me and my team will take are within that administrative sphere, where we're often asking the judiciary to scrutinise, to review, and it's an important tool in our box. And if you go to the court with a new area, which we have recently done, and we say, well, this is where the international obligations come from, here's an administrative route that we know in Scotland, can we marry it up? Where there is that clarity, then the judiciary will respond. And just to end, once you have that, it is important to support that, and that's where legal education and ensuring confidence within lawyers, ensuring that we have structures in place to ensure access. Because often when I speak and I will say, oh well, a woman has a right in that situation, and with that right there's a corresponding responsibility, the response I will get is, well, that might be the case, Kirsty, but it's not happening. And what do I say to the woman who comes to me? Where does she go? And then what does that lawyer do? What does that lawyer argue, and where do they argue it? So that when they get there, the judiciary knows what to do. So there is a need for education and awareness and all of that culture, and ensuring that we have the structures, but it only works alongside that clarity of commitment and objectives. And so I guess that would be my principles or things to consider from reflections in my practice.
Great. Well, it's really, really helping, I think, us to evolve our thoughts and our analysis. Thank you. That's really helpful. Jamie, I'm going to hand over to you now. Thank you very much.
Thanks very much. I couldn't possibly start without explicitly thanking the Scottish Human Rights Commission. Economic and social rights are in their infancy, we all know that, but they are where they are in this country, and by that I mean the United Kingdom, to a very large extent due to work that's been done up here in Scotland, and in particular by the Commission, both by existing people in the Commission and previous people in the Commission. And so there's a great deal of gratitude amongst people like Carla and myself who are spending our working lives down south, where the atmosphere is, I can reassure you, very, very different. And so it's beautiful to come up here. I mean, I was on the train and I was thinking, what's happening in Scotland? Is it like a sort of inexorable drive towards enforceable rights, or is it like a moment in the sun? And I got to Waverley and it was like beautiful sunshine. And I was like, oh no. But during the course of the day, it's absolutely obvious. This momentum is absolute. And so I completely take Douglas's point. But at the same time, I think everything suggests to me, even just the makeup of this room, there's only 9% lawyers, for God's sake. I mean, that's a very strong sign that there's buy-in here across the board. So for that, really grateful. Doubly grateful because now I don't have to talk about justiciability at all, because you all understand the basic principle that it's justiciable, and economic and social rights, I mean, are justiciable. And so I'm very happy to do a Douglas and abandon my brief and just talk about something else. So I wanted to, terrible lawyer. I wanted to speak about three things, one practical, one strategic, and one substantive. All of them are deliberately designed to raise attention, and they're all designed to be a bit provocative. I don't really know what I think about all three of them either. So the first is evidence, really straightforward point about equality of arms. If we're going to have enforceable rights, and I completely accept all the stuff about not resorting to court, it's not about suing the government all the time, it's about, as Katie described it beautifully, a constitutionally sound dialogue with a deliberative tinge or something. I can't even repeat it. It was so nice. But it's not about that. But when you do get to court, evidence really, really matters. In the cases that Colin talked about, for example, Kay and Cambridgeshire, it was one because the evidence was so good as to demonstrate that the absence of that benefit had real consequences. Exactly the same with the benefit cap cases. They're only in court really because the government's ostensible reason for the benefit cap, that it induces people to go into work when they wouldn't otherwise do so, is evidentially unsound. And that's how there's a case, fundamentally. And that's what lawyers understand and respond to it. That, in a way, it doesn't really matter what the rights are, as long as the evidence is good. Big question, though, where's that evidence going to come from when you're looking at macro challenges? And you need institutions to provide you with that objective evidence that you trust. Therefore, the institutions need to be accountable. And who is representative on those committees and et cetera, really matters. You can't ignore that part of the whole overall structure if you're going to have the kind of vibrant human rights culture we're talking about. So where do they come from, what do they look like, who sits on them? Big question. That was a practical one. The strategic one is this. For very good reason, a lot of the ESR movement, so that's a movement around economic and social rights, have used the language of incorporation. And what that really means is incorporating international law into domestic law to make it something that we can use and is enforceable. I think there is still a very real question, however, about how far we want to go with that approach. It's been the right one so far because the Bill of Rights issue, the British Bill of Rights, was such a toxic one, driven forward by a government which had no interest in human rights whatsoever, apart from to dilute the enforceability of human rights, that nobody could buy into that project. But at the same time, a wholesale adoption of an international perspective on human rights, I think, also brings some problems and cannot be ignored, particularly in the context of Brexit Britain, and indeed also in the context of a judiciary who aren't that persuaded that simply because an international committee somewhere, sorry Virginia, but that's the arrogance of our judges, have settled upon a general comment, that necessarily gives it intellectual or logical credence. So I think we might want to also remember that we do want these rights to be our rights in the sense that they'll be completely inspired by international standards, but they don't always have to be described as being an importation of international standards. And if a big part of human rights, and in particular ESR rights, is about participation, and that also includes local participation, at some point we have to cross that rubric and say, these are our rights now, they're no longer an international standard exclusively. So that was a strategic one. The final one is substantive. I just want to pick up on Carla's really brilliant demonstration of what we can already do. And a lot of what we can already do in this sphere really comes through a single prism, which is Article 14, discrimination. So even though the European Convention on Human Rights, or Human Rights Act, doesn't give us a substantive right to a home, for example, if there is a public housing scheme, it has to be designed and implemented in a non-discriminatory fashion. And it's exactly the same for welfare benefits, for example. So challenges can be brought on the basis of demonstrating these schemes are discriminatory. But that has some very real conceptual problems. Just very quick example. One, let's say you're a refugee concerned about a residence requirement on a housing allocation scheme. You have to have lived in the country for 10 years. Now, as a refugee, you are intrinsically less likely to be able to meet that requirement than somebody who is not a refugee. You're at an inherent disadvantage that is going to mean it's much harder for you to ever meet those qualifying criteria to get a house. Now, what is your argument? Do you come along to the local housing authority and say, build more homes so we've got more homes for refugees? Unfortunately not. What you end up having to do is come along and say, modify that rule for me. Make it easier for me to get a home vis-a-vis other people. So keep the 10-year rule for people who've had an opportunity to grant it. Give me a lesser rule. Give me 2 years or 3 years residence. Now, you don't need to be a lawyer to realise how difficult that can become and how divisive that can become as an approach to human rights. And actually, it's never going to provide complete answers. The benefit cap is another good example of that. It sort of became a bit of an auction of misery, really, that people needed to come along and say, look, the benefit cap is bad, but it's particularly bad for a certain cohort. So the initial argument in relation to the benefit cap was it's particularly bad for single parents. Most single parents are women, and therefore it's indirect discrimination against women. And the Supreme Court threw that case out, ostensibly for the following reason, that if they made an exception for single parents, there wouldn't be anybody left who was affected by the rule in the first place. It was basically an argument for saying you had to abolish the rule. And the court didn't have the power to do that, wasn't prepared to go that far. So benefit cap number 2, which is coming now, says, OK, let's now focus on single parents with children under 2 as a distinct cohort or are really, really badly affected by this rule. And the court has thrown that argument out also at the Court of Appeal level for the following reason. Well, really what you're then telling us is that for everybody else affected by the benefit cap, this is not so bad as to be unjustified. You're actually accepting the premise of the benefit cap, save insofar as it applies to a small discrete group. That's extremely problematic because the lawyers in the end weren't able to sufficiently distinguish that small cohort vis-a-vis everybody else. So we're sort of losing focus and we're ending up having a kind of almost a trade-off between different people affected because that's all discrimination law in that context gives us. It doesn't give us an obligation on the state to positively discriminate. Now, if we had enforceable ESR, we could take a slightly different approach. You could potentially have the refugee then come to court and say, this housing policy is not good enough because they are not building enough homes for people like me. That's the problem. It's not about the rules of allocation, it's about not investing enough money in the provision. The same with the benefit cap. You could come along and say, this just does not work for anybody affected by it because the statistics don't back it up. The government will tell you there's a 41% increase in the number of people who go into work simply because of the existence of the benefit cap, or people who wouldn't otherwise have gone into work. That is true, but the absolute numbers are tiny. It's something like 11% to 13%. So what about the other 87% of people affected? What happens to them? All the detriment that they experience only generates a 3% increase in the number of people who are actually going into work because of the benefit cap. Is that justified? Is that proportionate? That's the sort of challenge we could, in theory at least, have. So the value of all of this, as I'm trying to demonstrate, is it would allow us to have a much broader conversation in court about the allocation of resources. But that comes with attention. We are then starting to move to a situation where we're using human rights to talk about substantive equality, substantive material equality. Should we be living in a society where the gap between the rich and the poor is much less? And I'm not quite sure if the human rights movement has fully embraced that idea yet, whether it should, and how, if it's going to do it, it would do it. Virginia's committee has done some very interesting work recently looking at things like tax revenue raising powers, clamping down on tax avoidance, etc. When you're looking at maximum available resources, you do need to ask yourself, how big is the pie, and could the pie be bigger? Now that's hugely ambitious. It brings all sorts of other philosophical questions into play, political questions into play. And I think as a movement, however, if we want to keep ESR relevant and meaningful to people in their everyday lives, particularly in wealthy countries like ours. We need to work through some of those conceptual issues and make sure we all understand what we mean when we talk about equality in the context of ESR. Do we see it as a tool to achieve greater material equality, or is it just about guaranteeing minimum standards? That is an actual open question, I think, but one we should definitely be spending some time thinking about. My final reflection is this, that somebody said to me, to get us over the line on this, to get us into a position where we can really embrace the prospect of significant change, which might mean significant change for everybody in this room. It might mean much higher taxes, for example. We might need some kind of huge cultural event. And she went so far as to suggest we might need some kind of civil war. Of course, that is not what we need. But we perhaps do need to be a bit more alarmist about where this country is going in terms of the extent of material inequality and the damage it's doing to our social fabric. Because actually, I think in many respects, it's a unifying concern for all of us in this room, and indeed generally who work in aspects of social justice, that it's the terrible impact of such gross inequalities in this country which is causing the principal problem that we need to address. So my final point is if we are going to embrace that, we need to do it in a way which is fully conscious of everything that brings with it. If you know what I mean.
How are you all doing, It's really good. Thank you so much. Really, really impressive to hear this array of analysis and perspectives. So I'm finally going to rest the case, I think. It sounds like the case for the defence, definitely, to Case Brigham of Compass Chambers.
Well, thank you very much. I'm not just too sure what I'm going to say after all of that. First of all, I would like to thank the Commission very much for the opportunity to participate in this event. I've thoroughly enjoyed it. I thought I was coming here for a really relaxing day, instead of which my brain has been taxed beyond belief. Anyway, I'm going to just throw a few things in. I don't have any answers to any of this, but I do have some thoughts that I'd like to share in terms of things that I've learned from today's event. And the first thing that I'd like to say, in the words of Tom Jones, for MD who remembers the song, it's not unusual. Apparently, there is a normalisation, I think was the word, of economic, social and cultural rights within the world and within Europe. So the kind of idea that many of us, including myself, have about economic, social and cultural rights being somewhere up there in the ether, unable to sort of bring them down to earth, is really incorrect. And I think all of the speakers have certainly persuaded me that if there is such a notion, then that is wrong. One other point that I'd like to pick up on, and this is really going back to Katie's idea of throwing the books at the houses of the judges and the lawyers and such like. I think there is a serious point there, and I know that Virginia has said that it's not just about education, and I absolutely agree with that. That's not the answer. But if I think about the pre-Human Rights Act world, and I'm old enough to remember the pre-Human Rights Act world, we lawyers had to very quickly learn what was this European Convention on Human Rights all about? What was this Human Rights Act all about? What was this Scotland Act all about? And we had to really very quickly come to grips with all of that. But we haven't got there yet, even in relation to, I would suggest, the European Convention on Human Rights. Maybe that's me just speaking personally. So, in relation to economic, social and cultural rights, whilst I absolutely acknowledge that the courts are a last resort and that it starts with policy and government and legislature and policy makers and civic society, but ultimately, if there's going to be something that's enforced, then we have to have lawyers that understand what it is that's to be enforced. So that means that Mrs Miggins, as I was talking to Sheila earlier on about, Mrs Miggins, if she goes along to see her local solicitor, that her local solicitor has some understanding of economic, social and cultural rights, how those are to be enforced, so that the solicitor knows what to do, and if it involves coming to council, that council understands what to do. So learning is absolutely fundamental, it seems to me. And just picking up on the point about judicial resistance to the idea of rights, I think that anybody that's presented a human rights argument to the judiciary in Scotland, at whatever level, will have seen and will have met with resistance. I think it has changed, not totally, but I think as judges have been appointed who have grown up with the human rights culture, that it's less of an issue in terms of getting heard. But it will be an issue in relation to economic, social and cultural rights. But happily, Colm, I think, gave us an answer as to what we lawyers do if we're appearing in front of judges. We need to have a good understanding of what it is that we are arguing about and why it is legitimate for the judge concerned to make the ruling that we're asking the judge to make. We need to make it easy for the judges to do that, because they will be concerned and they will be anxious about whether they're stepping out with the boundaries of what they're entitled to do, and they're going to be on the Daily Mail front page as to going beyond what's acceptable. So we need to make it easy for judges, and that's hard, and that requires courage also on the part of lawyers who are putting these arguments forward. I suppose the other point that I mean, I've got lots and lots of points, but I appreciate that time is running out. But the other point that strikes me is that, at least in relation to courts and litigation, is that we have to have these rights litigated at the right level. It's not easy for anyone to try and enforce their rights. But if we have the rights available, as I say, at the right level, for example, if we're talking about social security, in the social security tribunals, that the rights are capable of being enforced within the tribunal structure. It may be in relation to housing and property, within the tribunal structure there, so that there's an access to enforcement of those rights. Because at the end of the day, not everyone, hardly anyone in fact, can afford to come to the Court of Session and seek a judicial review. So it strikes me it's very, very important to make sure that the rights are being enforced at the right level. And if I can just give you one example, which I was talking to someone else about, in relation to enforcement of rights at the right level. You know, for example, at the moment, if you are in receipt of universal credit, you're then sanctioned for one of the very many reasons as to why you're sanctioned. As a result of that, you end up not having enough money, therefore you don't pay your rent, therefore you're evicted, and that in relation to private tenancies would come through the Housing and Property Chamber, the first tier tribunal there. We have to be able to address that issue, not just on the case of the individual who comes, but on a more systemic basis, because it seems to me that's a systemic issue rather than an individual issue. So that means that if we're embedding rights at the right level, that all of us lawyers have to have an understanding of economic, social and cultural rights, so that when the individual comes to us, that we know what it is that we can do within the confines of the law. So the last point I'm going to make, and this is really touching actually on something that was said by one of the other panellists about the kind of divisive nature of the existing challenges. And I think that's true, that you're sort of setting one group against the other. in terms of, looking at social security rights and, is there a particular unfairness for this group as opposed to that group, and you're all fighting over the one pot. I think we've got to try and get beyond that, because it does tend to lead to the kind of Daily Mail approach. And what I would hope is that if we do have an incorporation of economic, social and cultural rights, that these are rights that are seen as for everyone, not just, the particular individuals, because ultimately it's what's fundamentally important to all of us. So, as I say, I've got lots of reflections, and I myself have learned hugely from today, and I look forward to the debate continuing. Thank you very much.
Great. So, really fascinating to hear those different perspectives from across a range of sort of disciplines and insights. There is time for questions, actually. We've got sort of 15, 20 minutes, and I really want to... I know you're tired. You may well all have fried brains, and I appreciate that. But actually now is a really good opportunity to probe a bit deeper, or to just to feel free to ask the question that really you might feel, is it this so basic that it's just not relevant? Please don't think that. It really isn't the case. Naomi.
Thanks very much, and thanks to everyone on the panel. My name is Naomi McAuliffe from Amnesty International Scotland. I just wanted to ask the panellists, I think particularly Jamie and Carla, but anyone to respond to this. You've both talked about the very different human rights context and environment between England and Scotland, and the toxic debate around human rights in Westminster, the dormant Human Rights Act debate, the fact that Brexit could open the way to potentially leave the UK withdrawing from the Council of Europe or the European Convention, that's still being, on the back burner and around. While at the same time, Scotland's going in a very different direction. I just wonder if you have thoughts on what are some of the risks of that. Will it kind of exacerbate that toxic debate down south? Not that that's a reason for us not to do it at all, but just what the risks are that we need to avoid. Certainly from Amnesty's point of view, trying to run a Human Rights Act, Save the Human Rights Act campaign, firstly it was very difficult to get one where the messaging would work across the UK, because when we were banging on about saving the Human Rights Act and saying that in Scotland, everyone just agreed with you. So then the question was, well, what else? And actually what we were calling for was something quite limited from a Scottish perspective. But if you start talking about a Human Rights Act plus or whatever incorporation bill in Scotland, are you drawing attention to some of the limitations of the Human Rights Act, when in fact we were doing a lot to try and say how good and how important it was? Are we actually opening it up for further criticism? But also, given the toxic debate around human rights have gone mad, the kind of campaigns that are being, not only certain politicians, but also the Daily Mail, the Sun, the Telegraph, running these campaigns against the Human Rights Act, would Scotland be going in this direction also? Demonstrate that here's more evidence of human rights going completely bonkers. So just a few thoughts about what are some of the risks that politically or in other ways that Scotland taking this trajectory might cause, and unintended consequences.
Thank you, Naomi. Would either of you like to have a go at that? Or both of you, even better?
I think there are definitely risks, but there are also obviously opportunities, which sounds like the most terribly bland answer, but I think that really is the sum total of it. I don't think anyone in England is going to assume anyone's gone mad in Scotland, so that one's not... Yeah. But I think... I feel this slight tension about the international and the domestic, which I've already hinted at. But one aspect of the international which I think is helpful is to try and ensure people understand how out of step England is becoming and what the risks of that might be. And Con talked about the social stat in Germany and the sense of a deeply ingrained approach to the social state, which I think Scotland, despite having essentially the same social attitudes as England, has managed to hold on to a little bit better than England. But I stress, the reality is that in England there is still actually very little appetite to roll back the state or roll back the welfare state. I mean, it's not really as prevalent as it might sometimes seem. What happened is, in times of austerity, a programme of reform to the welfare state was sold successfully in an election and a half. Because you had the coalition government in 2010, which got home with a kind of budget deficit, but we're going to look after frontline services approach. And then you had the Cameron Osborne administration, which was as cynical as they come, frankly, when it came to the welfare state, and just manipulated it for success in the ballot box, and did that to some degree of success. But the tide has already begun to turn on that a bit. So I'm not really sure that we're in a situation where we need to worry about losing the welfare state in England, but I do think we need to worry about losing human rights. And if that means we've got to prioritise HRA over ESR a little bit still in England, I think that's an absolutely fair price to pay. Also, final point on this very quickly, you know, if you bring ESR in an enforceable sense to England in particular too early, it could well backfire. And I think that happened a bit with the HRA. That opportunity is gone now, but I would hate us to make that same mistake again. And that's a comment that a number of people have made at different opportunities, and I've been speaking to people today, so I think we'd have to keep that in mind. And there's so much other work we can do with ESR yet, before you publicly call for incorporation, that we should be getting on with that work, perhaps, before we say too much about HRA+. And there is no appetite whatsoever amongst any of the people down south that I'm aware of to say, let's start talking about HRA+, i.e. the new Human Rights Act with incorporated ESR. We're not ready for that yet. We don't have the same moment of opportunity, the same moment in the sun, perhaps, that we have up here. That's just a reality I think we just have to face.
Carla, do you want to?
It's just really to reiterate a lot of that. I think, you know, if we were to, you know, wake up tomorrow and we'd incorporated economic, social, cultural rights, you know, in Westminster, then, you know, local authorities, lawyers, judiciary wouldn't know what to do with it, and, you know, it wouldn't have the real force and the real meat it needs. So there's a point that I was trying to make, that incorporation brings its benefits, but, you know, incorporation or not, there's things that can be done in terms of having a culture of understanding and actually enforcement by various other means of economic, social, cultural rights. I think in relation to Scotland, there's an opportunity for, you know, trailblazing, yes, or continuing to be in step with the rest of Europe and just making, you know, Westminster realise, well, A, that it's out of step, but also, actually, it's not the Scottish gone mad. It's not hugely different from what's already going on in relation to, you know, social security tribunals, etc. It's not this totally unknown concept, or this three-headed monster. It's not that different. So if you can set the path on that, then hopefully Westminster at some point will catch up. Yeah.
Can I make one? Just a really big up, though, for projects like the project in Leith and PPR and in Northern Ireland, things like that, because in England the same problem is present. If we're going to make human rights popular, we do need to go and work in areas where at the moment they're not so popular, but actually there are massive ESR deprivations. And a tiny charity called Just Fair that I'm involved in is about to try and do exactly that in Newcastle, which was a high Brexit voting area with a quite a strong resistance to human rights, but obviously with massive issues around social deprivation. And we are going to try and, in a tiny way, do something similar to what's been going on in Leith and in Northern Ireland, to try and see if we can start to change attitudes a bit by talking about human rights in a very different way at the sort of grassroots level, and worry about the politicians and everybody else a bit later on.
Yeah, Ellie.
Ellie Conservatis from Nourish Scotland. Hiya. My question is about the withdrawal bill, and as it's currently drafted, it centralises for up to 7 years a lot of powers which relate to socioeconomic rights in Scotland. The Scottish Government, for the first time in 20 years of having the ability to do so, has withheld legislative consent for that. My question is, if we do manage to secure some commitment to incorporation in Scotland, within the context which this withdrawal bill is operating, how long do we think it might take before we have kind of comprehensive progress and realisation on some of those rights which may be temporarily suspended in Scotland? No one has mentioned Brexit really, so I thought it was right to come.
I think we want to ask Craig French, who is a civil servant, couldn't possibly comment. I have no idea what the answer to that question is, and it's a brilliant, brilliant question. I suppose one thing to say is that perhaps the Supreme Court will give us a decision about the competence of the Scottish Parliament's own legislation on that. But other than that, I suppose in respect of those areas which are being taken back to Westminster, then the Scottish Parliament isn't going to have the competence to legislate in those areas. But it's not all about legislation, is it? I mean, I don't think that you just stop the conversation and the debate because of that. It might be a bit of an impediment and a bit of a barrier. Don't deny that. But the cultural aspect of it can continue, I think. Anybody else have a view?
I think the point about it's not all about legislation is right. I think it's all about kind of, rather than worrying about the what ifs, look at what we can do at the moment and focus on that. Because I think there is a lot. I mean, the Scotland Act gives the powers that are there at the moment, as far as I understand it. It can go ahead and give further effect to the Covenant on Economic, Social and Cultural Rights, and do that, and then worry about the other bits afterwards. And in so many ways, I think there has to be a sort of commitment to work within the powers that are currently there, and then let the other things work themselves out from there. That's maybe completely legally incorrect, but it just feels as a point of principle, feels that's the right thing to do.
Okay, there's no other immediate questions. I wanted to make the point from the Commission's perspective, and it's been referred to a lot today, about the cultural aspects and about changing culture as a way of potentially supporting a change in legislation or supporting a progressive shift in terms of legislation. And really, today is not about an awful lot of the rest of the Commission's work, which is all about that change in culture. And people have referenced our work in Leith, which is effectively borrowed or stolen, one might say, from our granted from PPR's experience in Belfast, with that sense of a bottom-up approach for me, which is very much the other side of human rights, which is not about a judicial route but about holding public authorities to account through the empowerment of individuals who are the rights holders. And that process of enabling that to happen is a huge part of our work, and supporting those rights holders to understand understand what rights people have, how to access those rights, and even in a context where they're not currently justiciable, they still have weight, they still have relevance and resonance, and they are worthy of a conversation with the public authority who, while they may not understand in any given one moment, they certainly come to understand when the right either pressures are brought to bear or conversations are had, or probably at this point most successfully the right individuals are found who have a bit of understanding of some of the core principles of human rights that can then learn about the rest of it and take it into their practice on a more integrated basis, which is to some degree what we've seen through the Leith housing project. And I was going to somewhat optimistically encourage you to go to our website in the knowledge that the resources really telling you a lot more about the Leith project aren't there yet. But they will be there in time. But there is a short video which tells you the first half of the story, and we're currently filming the second half of the story, which really reports the success that the residents there have had. And for me, that's that and many other efforts. And I was talking to Alan Miller at the lunch break, and he was saying that it's really interesting that, for example, the prison inspectorate have really rewritten their standards, their inspection standards, to wholly incorporate international human rights standards in their inspection regime. Now, that has the potential to significantly shift the culture to be fair, that's supporting a shift which is already happening in reality in prisons in Scotland today. Now, if our UK counterparts at England, for example, or even in Wales, took on board that same process, we might see a slightly different outcome for some of the reports that the Prison Inspectorate in England is communicating. So that those different ways of, whether that's in the strictly legal sense, incorporating human rights in a broad language sense, that is incorporating human rights into our broad culture and our practice and our ways of functioning as public bodies in Scotland. And I would say that's not a process which has reached what I would describe as a tipping point yet, but it's a process which is incrementally and I hopefully think inexorably coming towards that tipping point, where increasing numbers of public authorities are sort of waking up to the reality of a rights-based approach actually is something which not only they need to as a result of it being part of their obligations and duties as a public authority, but actually gives them something additional in their analysis. Health Scotland, Kath Denham from NHS Health Scotland is here, where their board has taken a strategic decision to take a rights-based approach and incorporate the right to health into their policy-making practices across its organisation. Now, the right to the highest attainable standard of mental and physical health is something we have not achieved in Scotland. We're a long way away from that, actually, for many individuals. And so that's a start for me. And if NHS Health Scotland and the future reformed body take that into account and then bring that into more health board practice right across the trusts in Scotland, we could see that transformation really taking place, rooted in a public authority's delivery mechanism. So for me, that isn't the subject of today. Those other routes to that culture change that today has all been about incorporation, justiciability, seeing the role that the law can place to bring that into life in Scotland. It's absolutely, for me, it is that backstop. It's the top line. It's the political will. It's saying something of where we want to get to, where we want to be as a country, and it's really important to have that backup. Because one of the things we did see in the Human Rights Act, for example, is that moment of, oh my goodness, I have to give this serious consideration. Build it, and they will come. Just do it, and then see what happens. Now, other evidence says if you just do that, then there is the potential for it to backfire. So we're kind of in that moment where we've done some work to change the culture. Now we're looking at the law, and a few more years, and I actually do think it's picking up pace. It wasn't like this 10 years ago. As somebody said, we couldn't have this conversation in Scotland 10 years ago. 5 years ago, pretty difficult and a much smaller room. Today, this is the conversation we're having, and we were sold out. So that's an indication of the momentum that's being generated, not just by the Commission, but by many stakeholders across Scotland and in communities, and seeing that process happen. I've unwittingly sort of done my concluding remarks. That wasn't my intention. That wasn't the brief. But anyway, I think I will leave it there for today. My final job really is to say a huge thank you. There's very many people to thank. So I want to thank all our contributors, all our panellists. I want to thank Virginia for making the journey en route to another meeting that she's having in New York. I want to thank Katie and Com for really making very rich and incredibly experienced contributions. All our panellists this afternoon for sharing that different perspective and insights, and really all of you for bearing with it, for really grappling, as I could see across the room, with the issues and the conversations and the dialogue. So that's hugely supportive of this process as we go forward. I also want to thank the staff of the Commission. Clearly, bringing all this together, from the analysis, the idea, the conception, the effort and energy to bring this into this room with all of you is considerable. And somebody said to me, I'm not sure who it was you, Carla, at lunchtime today, we are only 10 staff. And that has a bearing on both, not the quality of our work, but definitely the quantity. So I really attest to the resources and the support that the staff have put into this process. I'm going to ask you to log back into Mentimeter. Please do that. We have a few minutes just before we finish. And we've got the code 562334. And you will have back to your sliding scale messages. If you didn't answer it first, don't worry. And see what your thoughts are now. See how if indeed we've moved you.
Racing horses.
I'm just waiting for my counter to go up. Keep voting, folks, keep voting.
Maybe quit while we're ahead.
No. Okay, so I would say that's a shift. I can't remember the exact figures of the first one, but I think the notion that the Human Rights Act has all the protections we need has definitely reduced. And the two figures around legal framework should go further, and positive lessons we can learn from international, I would say, have grown, although clearly when we started you were fairly convinced of that, to be honest. So that's really helpful. So we will also be sending you a short link to a SurveyMonkey forum, and the films will be available. The narrative from today, the slides, all the conversations that we've been having will be available in time, not immediately on the Commission website, but they will definitely get there. And we will be publishing further material on the topic. So the reports from our workshop series on health, social security, food and housing will appear. They will be published, and then Katie's report, which she's been working on, absolutely will be published. That will be a pretty comprehensive analysis of much of which you've heard from today, but clearly there'll be more to that. And as you know, we are contributing to, but we also really are looking forward to the recommendations coming from the First Minister's Advisory Group as being, setting us on a new trajectory in relation to the provisions around economic, social, cultural rights and how we do demonstrate that leadership. It's interesting that our leadership role now feels like, oh, right, okay, so well, actually other people are showing considerable leadership, and we even in the European context have got some catching up to do. That's also, I think, reassuring. So thank you very much, everybody. Great to see you. I'm sure we will be in similar rooms again, probably in the very near future. So thank you very much for your presence today.